behavior of giving cats a shower. Dees observed the cat being soaked, water on the floor near the toilet, and cat hair in the toilet. The issue pertaining to petitioner's Exhibit 3, the family posting or Facebook posting, predates the subject child, blah, 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 whatever. He kind of goes on that. Appellate testifies she does not have the child call anyone else dad, nor does she refer to anyone else dad as dad. What the posting pre-birth of the subject child and pre-establishment of paternity never came to fruition. You see what I mean? Like, there's issues with paternity. It should be noted, it is uncontroverted that petitioner respondent was not financially supporting his child. There's a digital printout of money petitioner paid appellant, and it appears it was paid when the parties cohabited. Petitioner respondent father moved to Rochester, New York from California. He has no family in the Rochester area. He further does not have any family in Pennsylvania, where the appellant resided at the time of the trial. Contreras took the stand as a rebuttal witness. The court allowed screenshot text messages into evidence as petitioner's aid over Dees' counsel. The text messages predate the birth of the subject child and are irrelevant. The court again allowed more text messages into evidence with the omission of petitioner's Exhibit 9, overruling an objection. The conclusion of the July 15th, 2024 proceedings, the court being well aware of the proceedings Dees commenced in Pennsylvania, directed Dees to produce Sevyn to the next trial date of July 22nd and ordered there was a visit over the weekend between trial dates. July 23rd, 2024 was the last day of testimony. Contreras continued to testify and provided damaging testimony to his case. After the child was born while you resided with Mrs. Dees, you were never the primary caretaker, correct? Answer, no. Care was shared. Question, and you've never had the child overnight alone, correct? Answer, correct. Since Contreras started working at RG&E, he admitted he has not paid child support, but denied knowing he was in child support arrears. Since Contreras worked, Contreras was well aware that Dees has family in Pennsylvania. The court prevented Dees' counsel from getting into proposed access over Thanksgiving, which was an error by the court. The court, in its decision, order, held it against Dees that Contreras showed up for access with an open protective order from the Court of Common Pleas in Pennsylvania as an effort of Dees to thwart access to Contreras. Right, so basically, when I had an order of protection in Pennsylvania, she was trying to make me do visits that went against the order of protection in Pennsylvania, and then held it against me that I wasn't going against the order of protection in Pennsylvania that superseded the order that she was trying to give. Okay, so argument point 1. Here's where he kind of gets into the meat of, where she really went wrong here. All right, so the record lacks a sound and substantial basis in the record. The evidence within the record supports granting respondent petitioner mother primary residential custody. The Court of Appeals in Fred Weitzer versus Fred Weitzer, New York, blah, 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 set forth numerous factors the court must consider in determining the child's best interest, which consists of 1, the quality of home environment and parental guidance and the custodial parent provides. The financial status and ability of each parent to provide for the child, the ability of each parent to provide for the child's emotional and intellectual development, the demonstrated parenting ability and demonstrated fitness of the parties, the love and affection and nurturing given by each party to the child, the emotional bond between the child and each party, the willingness and ability of each party to put the need ahead of his or own, the willingness and ability of each party to facilitate and encourage a close and optimum relationship between the child and the party, the individual needs of the child or desires and preferences of the child, and the other factors the court may deem relevant, particular to custody dispute, domestic violence, and impact on the child. And then cites another case. When the record lacks a sound and substantial basis, this court does not have to afford a trial court deference to its findings. There is no evidence within the record that the mother is unfit to care